Next, may I bring the jury?
Present, Your Honor.
All right. Cross-examination.
Good morning.
We received an explanation yesterday of what a crime scene investigator does. And if you would give us the background that you have before you took the job in terms of your training, academic training for this position.
I have a bachelor's degree in forensic science from Baylor University in Texas, and I have a master's degree in forensic science from Marshall University in West Virginia.
So when you came to SLED, you had a pretty substantial, compared to others employed in your position, in terms of the academic training, is that correct?
That's correct.
And on April 4th, when you responded to Charleston, would it be fair to say you were the junior member of the crime scene team?
That's correct.
And the crime scene team from SLED was composed of you and Mr. Brown?
Yes.
And did you rely on anyone from the North Charleston Police Department to provide any services on behalf of your evidence collection?
Not to my knowledge, no.
And did you rely upon any one other than SLED to search the grounds where the crime scene was cordoned off?
Not when I was present at that location.
Do you know whether there was ever, could you tell the jury the type of searches that one would employ at a crime scene?
It varies from scene to scene, depending on the type of scene that we're at.
And they can be grid searches, can they not?
Yes, they can.
And a grid search would be dividing up the crime scene into different little squares or rectangles and eliminating one by one any evidentiary value of that location. Is that correct?
That's correct for that type of search.
And there are also line searches,
Yes.
and that would be that we could have anywhere from 2 to 20 officers walk in a line and look for evidence.
That's correct.
Is that correct? And then there are spiral searches as well, correct?
Yes.
And that would be sort of like a snail's shell where you just keep searching it. Is that correct?
Yes, that's correct.
And are there any others?
I know there's a zone search where you can break certain scenes down into zones to search as well.
Now, given the geography of this particular area, which search was best?
I would say there'd be a number of those types of searches that would be adequate for that scene.
And which one was performed?
A search was not performed while I was there.
By anyone?
I can't comment as to whether something was searched before I arrived.
That search, if it had been performed, would have covered the entire crime scene to look for items that would contribute to the information you provided to the jury in your testimony. Is that correct?
Yes, that's correct.
And we know, for instance, that the 2 projectiles that were found by citizens, not by law enforcement. Is that correct?
That's the first time hearing of it.
You didn't know that, I believe your testimony was that somebody was associated with my office found the 2 projectiles?
Correct.
And nobody from law enforcement found those, is that correct?
Not that I'm aware of, no.
And the wooden fence that you showed on the photograph, just walking by that fence, you could see the defects, the holes in the fence, very clearly. You didn't need any instrumentation or anything of that nature to find it. Is that correct?
I personally didn't walk by the fence that day.
Did you ever walk by the fence? Did you ever see the defects in person?
Yes, I did.
And they're clear. I mean, there's nothing secretive or hidden about the defects in the fence. Is that correct?
That's correct.
And when something impacts a wooden fence like that, based on your training and experience, had you seen those, you would have known those were fresh marks.
That's correct.
And based on your training and experience, you would know that there was an entry hole and/or an exit hole. Is that correct?
Yes.
So the photograph of the leaves, it was a lot harder to see the bullet in the leaves, correct, than it would be on the hole in the fence, correct?
That's correct.
But once one sees the hole in the fence, you'd start looking for further evidence, correct?
Yes.
And do you know the type of instrument that was used to find the bullets?
I believe it was a metal detector.
And you know what type of metal detector it was?
No, I do not.
You know that it was a Fisher-Price toy?
No, I do not.
The point is, it wasn't complicated to find those bullets, correct?
Apparently not, no.
And in the crime scene itself, did you or did somebody under your direction or somebody you gathered with collect the taser wires?
Yes.
How many were there?
There was one cartridge that still had wires attached to it with 2 unattached wires and another cartridge that had taser wire attached to it.
And did you examine those wires?
No, I did not.
Did anybody from SLED's crime scene, to the best of your knowledge, ever examine the wires?
No, they did not.
If they had examined the wires, they would see that the wire itself was covered with an insulator. Is that correct?
I don't know.
Have you seen the taser wires in evidence?
Yes, I have.
Have you seen other taser wires?
Yes, I have.
The taser wire in evidence is a typical taser wire, correct?
It appears so, yes.
And it has an insulation. Is that correct?
I'm not familiar with the taser terminology you're referring to.
A wire is conductive, is that correct?
Yes.
A insulation is non-conductive, is that correct?
Sure.
Is plastic a non-conductive insulator for wire?
I believe so.
Do you know whether or not the wires have insulators?
I don't.
Now, do you know the length of a taser wire that extends from the taser itself when discharged the full distance?
I believe there are different lengths associated with different models of tasers.
Did you know or do you know now the length of wire associated with the taser that's in evidence?
25 feet, I believe.
And has anyone measured the length of the wires in evidence?
Yes.
And tell us what the finding is.
I personally didn't measure it. Somebody from the solicitor's office had measured it at the lab.
The prosecutor's office?
I believe so.
Well, let me ask again, did anybody who's an investigator measure?
Are you referencing crime scene investigation with SLED?
Anybody that you know of who's not in the prosecutor's office measure that?
No.
If the prosecutor had indeed measured it, there'd be some type of report or something that this jury could learn about how many wires were found. Is that correct?
Can you repeat that question?
Well, let me give you an example. Let's say that somebody testified that there were 4 wires found. Somebody could measure those wires to see really whether that's one wire that's been cut. If they know the length of what the wire was when it was discharged from the taser. Correct?
Yes, that's correct.
So that if somebody attempted to mislead someone else by saying there were 4 wires, when in fact that there was one, that's a matter that should be cleared up. Shouldn't it?
I object to him, his form of this question.
The objection is sustained.
No question that the wires could be measured.
Yes, the wires can be measured.
And no question that the wires could be matched end to end where they were broken, if they were broken, to link those broken pieces together.
I don't know if they can be matched end to end.
No question that a wire could be looked at to see if it had been stretched, if the crimps in the wire have been taken out.
I'm not a taser wire expert.
What type of expert would it be to have to know whether or not the crimps in a wire are taken out?
I don't know.
You know that it's important in terms of evidence and the type of evidence this jury gets to see,
Sure.
but it just wasn't done.
No, it was not.
Now, with respect to the prongs at the end of those wires, how many did you or your colleagues collect?
Those are referred to as taser probes, and we collected 3.
And how many would there have been if the taser had discharged twice?
There would be 4 taser probes.
What effort was made to find the 4th probe?
I personally did not search for a 4th taser probe.
What effort was made by anyone? And there must have been 30 or more people in the crime scene, correct? Law enforcement people.
At the scene, yes.
And which one of them got together and did a line search or a zone search or a grid search?
I can't comment as to who searched before I arrived on scene.
Which one of them took a metal detector, whether it's Fisher Price or some expensive one, to look for that probe?
I can't comment as to who searched before I arrived on scene.
What would have been the evidentiary value to this jury to get the complete information about this crime scene if the probe had been found?
That would have been helpful to find a fourth probe.
Because absolutely unequivocally, examination of that probe would say whether or not it was ever conducted electricity. Isn't that correct?
I don't know if that's correct.
Well, if somebody said that somebody was tased twice for a period of 10 seconds, if that had been argued by a lawyer in a case in front of a jury, there'd be proof of whether that's true or not. Isn't that correct?
I don't know if there would be proof of that being true.
Now, at the time of 12:06 on April 4th, you arrived at the North Charleston Police Department, correct?
Yes, that's correct.
And the purpose of your job, based on your training and experience, would be look for and gather evidence, information that would be helpful for this jury to make the decision they have to make. Is that correct?
That's correct.
And when you arrived at the North Charleston Police Department, the photographs that we saw earlier, Mr. Slager had already changed clothes. Is that correct?
Yes.
And Mr. Slager's weapon, had that been removed from him by the time you got there?
It was still present in the holster on his duty belt.
And when you arrived, did you put on those blue gloves we see to protect the integrity of the evidence?
Yes, I did.
And tell the jury why you do that as a crime scene investigator.
That's to prevent us from contaminating evidence that we come into contact with.
And it's not just you, anybody who touched it. If I was there that day and touched it, it would contaminate the evidence, correct?
Yes, that's correct.
So, do you know how many people touched the taser without gloves before you obtained possession of the taser?
No, I do not.
So, you took the taser and you examined it or you performed a test on it to identify who may have touched it. Is that correct?
I swabbed the taser for touch DNA, yes.
And the purpose of doing that is to identify who had touched the object. Is that correct?
The purpose of that is to potentially develop a DNA profile from the object that's swabbed.
Tell that in layman's terms, if you would, to the jury. What does that mean?
The taser itself was swabbed, the entire exterior of it, and we hope to develop a DNA profile from touch DNA, which are skin cells left over after somebody has handled an object.
And the particular touch DNA means skin cells, is that correct?
Yes, that's correct.
Before you examined it for skin cells, did you examine it for sweat or blood or any of the body fluids?
I don't examine things for sweat or skin cells. They're swabbed, but I don't examine them for that.
Did you look in the crevices of the handle to see whether there was any blood in those crevices?
No, I did not.
And we know that that would be a different type of DNA examination that could be done if in the grip of the handle of the taser there was evidence from somebody, either blood or sweat, correct?
If blood had been present on the taser would have been swabbed differently.
And that examination, a visual examination of a dark object, does not necessarily say whether or not blood is present or not, correct?
That's correct.
But there are means, different light sources that can illuminate the blood if there was blood on the taser.
Yes, that's correct.
And that wasn't done.
No, it was not.
There was an assumption made that there was touch DNA, correct?
No assumption was made. It was just swabbed to see if we could develop something from the swabs.
No question that before the examination took place, you were aware that there was a struggle, not just between bodies, but a struggle over the taser, correct?
That's correct.
And no question that that Officer Slager had actually demonstrated to Chief Griggers what happened in terms of the struggle at that point. Were you aware of that?
I was not aware of that, no.
So it wasn't passed on to you that there was a physical struggle over the taser?
That portion of,
It's facts, not evidence, you know.
Objection's overruled.
Were you
It's
aware?
either yes or no.
can you repeat the question?
Part of your evaluation of evidence is based on your knowledge of how that evidence applied to the case. Is that correct?
Yes, that's correct.
So that if you were aware, and I don't know whether you were, if you were aware that there was a struggle over the taser, that would direct the processing that you employed on the taser. Is that correct?
Yes, that's correct.
And did you know that at the time you examined the taser, that there was a struggle over the taser?
Yes.
And are you aware on the surface of the taser that there are many areas suitable for fingerprints? Are you aware of that?
There are some areas on a taser that may be suitable for fingerprints.
May I approach? You see the taser?
It's right
Hot, warm, colder?
there. Thank you.
I'm looking at State's Exhibit 49. Agent, if you would remove it from the package.
I'm sorry, can you say that again?
I'm sorry. Would you remove it, State's Exhibit 49 from the package? So if you would, I heard you mention this morning that the red portion of that is really not part of the taser, is that correct?
That's correct. It's a safety clip.
So does the taser have a battery in it now?
I believe so, yes.
Can you remove the battery and then remove the safety clip, please? So if you would stay right where you are, would you show the jury the operating end, that is if somebody were to be drive stunned, the area of the taser that would touch the person who was drive stunned?
Well, it depends whether or not a cartridge is attached to the end of the taser.
Assuming that the cartridge had been removed,
It's this end of the taser that would be in contact with an individual.
does the taser you have in front of you now, State's Exhibit 49, have a cartridge on it?
No, it does not.
So that what you're just showing to the jury would be where one would look for DNA if there was an allegation that somebody had been tased. Is that correct?
Are you referring to the front end?
Yes, the business end of the taser.
Yes.
And if somebody said that there was a struggle over the taser, where would you look for DNA?
I don't look for DNA, I swab for DNA.
Where would you have swabbed if somebody had indicated that there was a struggle, if you would point the taser, it's unloaded. If somebody, you were holding on to it and I was trying to take it away, where would you look, where would you swab for DNA?
In the example that you just gave me,
Yeah.
I would swab the portion of it that you had touched.
If somebody had used the taser, where would you look, where would you swab for DNA?
The handle portion and also the trigger.
And where on that device would you look for fingerprints?
You could look at the entire exterior surface for fingerprints. However, this surface is not usually conducive to maintaining fingerprints.
And that is because it has a waffle-like surface, is that correct?
That's correct.
Look at where it identifies itself as an X26,
Yes.
if you would show the jury where that is.
It's on two sides.
And that's where, if somebody tried to struggle over the taser, that's the particular area that would be held, is that correct?
I can't comment as to where something may or may not be held during a struggle.
But no question that fingerprints could be retrieved from that area, depending on the circumstances.
They could be retrieved from that area, yes.
Now, certainly fingerprints and DNA can be obtained from the same object, isn't that correct?
That's correct.
So when one investigates, one gathers the evidence that hopefully a jury would see someday, there's a method and a process to determine what would be non-destructive testing, leading at the end to more destructive testing. Is that correct?
Yes, that's correct.
So is DNA destructive?
Not how this was swabbed, no.
Is fingerprinting destructive?
Some fingerprinting processes are destructive, yes.
So in this particular instance, we could do DNA, complete that, and then move on to fingerprint testing. Is that correct?
Not for this particular item, no.
Why not?
With this particular item, given that it is black, for fingerprint processing to be done, it would have had to be superglued inside a chamber. Cyanoacrylate fuming is what we refer to it as. And there is a potential that that could have destroyed the functioning of the taser.
All right, well, the functioning of the taser, that would have been destroyed.
Yes,
But you could have done DNA first, correct?
yes, that's correct.
It wouldn't have done anything to the taser. You could then check the functioning of the taser, wearing the gloves that you have on, preserving the evidence in its best state, and then determine at some later time the functioning of the taser. Because all things aren't done at one time, correct?
That's correct.
There's staging. You do the first test, and the second test, and the third test, and on and on and on. Correct?
Yes,
There was no reason in this case not to do both DNA and fingerprints. Is that correct?
the taser was swabbed because the surface is not conducive to latent prints.
Even though you just said where the X26 is a suitable area.
That is an area that may be conducive to latent prints, but we don't spot process.
And there's also another area on the handle that's suitable for latent prints. Is that correct?
There is a possibility that surface may maintain fingerprints.
But possibilities only turn into reality when they're tested. Your statement of possibility is only possible because it wasn't tested. If it had been tested, then it would be probable. It would be absolutely this surface wasn't good, or whatever reason you want to use. When there are possibilities in the science of evidence collection and examination, everything's possible, correct?
I can't comment as to whether everything can be possible.
Well, possibilities only turn into reality when they're examined. Is that correct?
Yes.
And this item was not examined.
For fingerprints, no.
Well, let's talk about DNA. How many swabs did you use to collect DNA?
2 swabs over the entire exterior surface.
And would you show the jury, please, where you swabbed on that case?
It would have been, again, the entire exterior surface to include the trigger inside, the handle, the back portion, the top.
How about the business end of it?
I don't recall having swabbed the business end of the taser.
So when you say you swabbed the whole instrument, the business end where it would have touched somebody, if it was used against them, was never examined.
I wasn't aware that this end had touched somebody.
The 2 swabs that you took of the taser, do you know what happened to them?
After the item was swabbed, the swabs themselves were dried and given to Agent Brown.
And those swabs both took, were probed for DNA in the same areas on the instrument on stage 49, is that correct?
I can't speak as to what areas of the swabs were looked at.
As far as the swabs, you did the swabbing.
Yes, I did.
Did you do swabbing with one Q-tip on one side of the instrument and then put that down and pick up another swab and do the other side of the instrument?
No, it's 2 swabs held together over the entire surface.
And when the swabs, the 2 swabs got to the lab, they were combined to discover what DNA might have been there.
They've always been combined.
So if you had 4 or 6 or 8 or 10 Q-tips and swab different areas of the taser, they could maintain segregation until they got to the lab, and the lab could have combined the 2, 4, 6, 8, or 10 swabs to obtain DNA. Exactly.
I don't know if they combine swabs in that fashion.
Well, you had indicated in your testimony earlier that you were afraid that there wasn't sufficient quantity of DNA, and that's why you swabbed the whole instrument.
That's correct.
Are you aware that swabs can be combined in the laboratory so that there wouldn't be any reason to use one swab over the entire instrument?
1 swab was not used over the entire instrument.
The 2 swabs that were used together were used over the entire instrument, correct?
Yes.
Were you aware that you could have used different swabs in different locations, even with a minute amount of DNA, to be combined at the lab to make it suitable?
I'm aware that you can use multiple swabs in multiple locations, yes.
But that wasn't done.
No, it was not.
And you know that the DNA that was found by the lab on that taser was Walter Scott's, correct?
Yes.
And you know that the greatest quantity of DNA found on that taser was Walter Scott's.
I don't know whose quantity was greater.
And this is a murder case. This is a murder case.
Yes, it is.
Most serious case that can be tried in this court. Correct?
That's correct.
Now, when you went to the North Charleston Police Department and you photographed Mr. Slager, Officer Slager, were you aware that he had already washed his hands, cleaned up the wounds that he had? Either he personally or somebody else had applied medication, treatment, and cleansing material to those fingers?
I don't believe I was aware of that, no.
Did you ask?
I usually ask before performing a gunshot residue kit if somebody has washed their hands prior to taking the kit.
I'm talking about the areas where he was bruised, the area that was still bleeding when you got there. Did you ask if anybody had provided medical attention to those areas?
No, I did not.
And the photographs that you took don't seem to indicate bleeding. When were they bleeding when you saw them?
He actually bled on my chain of custody that he filled out for me.
And between the chain of custody that he filled out for you and the time you took the photographs, did somebody apply some medical treatment to those injuries?
Not that I'm aware of, no.
Even looking at your photographs, you know there were other photographs. Did you take the other photographs?
Which other photographs are you referring to?
You recognize this photograph?
Yes, I do.
Is that a photograph you took?
I believe so, yes.
Does it accurately reflect the image in the photograph at the time that you took the photograph?
Yes.
John Woodall, this is State's Exhibit number 18.
Without objection.
It's admitted without objection.
The photograph that you put, that you identified earlier when the solicitor asked you about the photograph of the hand, could we put that back up? Photograph of the hand.
Is it one of these?
Yes. What number is it?
142?
The picture that you just identified as Defense Exhibit 18, could you put that up, please? John? Well, from looking at defendant's 18 that's in front of you, here it is now, and the photograph that you previously displayed to the jury, is there a difference in the two photographs?
In reference to,
The injuries?
Your Honor, this is the point that don't appear to be the same. Defendant's 18, so, sir, that doesn't appear to be defendant's 18 in the show. Am I correct? Is there a comment? It's not the same photo.
Well, they look for that. This is all. But when you went to the North Charleston Police Department, you took photographs of Mr. Slager. And you obtained his shirt and you obtained his pants, correct?
yes,
And did you obtain those things that hold the shirt in line, in place? Did you obtain that? Whatever the garter belts or whatever, that hold the shirts tight.
no,
Did
no,
you-
I did not.
you obtain that?
No, I did not.
Did you obtain his duty belt? His, what we see law enforcement, the big thick belt and handcuffs and all that. Did you obtain that?
No, I did not.
Did you obtain anything other than the shirt and pants, no shoes, no duty belt, no anything else, what they call assets, the assets that he carried that day? Did you obtain any of that?
No, I did not.
And of course, as an evidence collector, there may have been some evidentiary value in that to show that there was a struggle, correct? You knew from looking at the uniform that there was dirt all over the uniform. You looked at his injuries and realized that there must have been some type of struggle that was employed that morning. And wouldn't it be logical then to obtain the duty belt to look for evidence of scrapes or scuffs or perhaps bodily fluids?
That could have been done, yes.
It was not done.
No, it was not.
It was done later though, wasn't it?
The duty belt was collected later, yes.
Because somebody realized a couple of days later that, hey, we overlooked this and went back to get the duty belt, correct?
I was not aware while I was at the police department that a request had been made to collect the duty belt.
You didn't make that request.
No, I did not.
And you're the crime scene evidence technician that gathers evidence.
I was at that location, yes.
And you didn't ask for the duty belt.
I did not know.
You didn't ask for the radio.
No,
You didn't ask for the microphone that was used that day.
no.
Now, how much later was it that somebody tried to obtain the duty belt, the radio, the microphone, the vest that Mr. Slager was wearing that day?
We've never been in possession of the vest.
How much later did SLED try to obtain the vest?
To
How
my-
many days in between the event and the time that somebody said, hey, we better go find stuff?
I don't know how many days afterwards in reference to the vest.
How many days afterwards with respect to the duty belt?
I believe it was 6 days that it was turned over to me.
And at the time that the duty belt was requested, did you obtain the radio?
Within the duty belt?
Yes.
I believe so, yes.
And did you obtain the microphone?
I believe so, yes.
You want to check your notes before you testify further to see, refresh your memory?
I don't have in my notes the contents of every single item on the duty belt.
But every single item would be important, correct? The microphone to test the distance that it worked, the radio to test to see if there was any scrape marks on it, the duty belt to see if there was any blood stains on it or trace evidence of any type. All that is important, is it not?
Yes, that's
All
important.
that would be important to see how much it weighed, so one could say if somebody ran 200 yards with the extra weight on, how exhausting that would be. Isn't that correct?
Objective for the question.
The objection's overruled.
Can you repeat the question?
If there was a statement, as I believe it was made that morning, that Officer Slager ran some 200 yards,
City's facts, not evidence.
if there was a statement that morning that Officer Slager made where the chase started and where it ended, and somebody figured out the distance in between, it would be important to realize he's not running in a tracksuit or in short pants. He's running with a uniform and weight on him that would exhaust him more than the ordinary person running that distance. Isn't that correct?
That information had not been told to us at that time.
You didn't know that he went from the AutoZone location up Craig Street, turned right, went down Yellow Brick Road? You weren't aware of that?
That information, yes, but not any specific distances in reference to weight that he may have run.
Let's start with distances. What is the distance from where his car was parked to the entrance to Yellow Brick Road?
I don't believe those measurements were taken.
What is the distance from the entrance of Yellow Brick Road to where the fight took place?
I don't believe those measurements were taken either.
Would that be important for the jury to know so that they can consider the physical and mental status of Officer Slager after running that distance?
Locations and distances were not made aware to us at the time that we were on scene.
I thought you photographed the car on scene.
We did, yes.
And I thought you photographed the markers where the wallet and the hat were.
That's correct.
It's just that nobody thought to measure the distance. Is that correct?
Those distances were not measured, no.
Now, as to the car itself, was Officer Slager's car inventory?
No, it was not.
Was Mr. Douglas, was Mr. Scott's, God bless you again, was Mr. Scott's car inventory?
No, it was not.
So that this is the car that was being driven by Mr. Scott that morning, that Mr. Scott ran away from, ostensibly because of a broken taillight, or others would believe for running away from a bench warrant for a family court action. And it wasn't inventory.
No, it was not.
Now, photographs were taken, correct?
Yes, they were.
Mark is 19, defendant's 19, you recognize that?
Yes, I do.
And let me show it to the prosecutor. Your Honor, we move defendants 19 evidence.
Here's without objection.
Would you tell the jury what that photograph represents?
This is a vehicle registration for
For what?
the, go ahead.
It's a vehicle registration, South Carolina registration form, correct?
Yes, that's correct.
And for what vehicle?
This is for the vehicle that Mr. Scott was driving that day.
Where was it found?
I don't recall where it was found. Inside the vehicle.
How about in the glove box? Does that refresh your memory?
Sure.
Was it found in the glove box?
I don't recall where it was recovered from.
So along with the registration, was there an insurance card?
I don't recall whether or not there was an insurance card as well.
Who else explored the interior of Mr. Scott's vehicle?
Agent Brown.
So either you or Agent Brown would have written down someplace what was inside the vehicle, correct?
It's possible he may have written that down.
But you did.
I didn't know.
And working in tandem, you weren't checking on each other, you just assumed the other was doing their job, correct?
We do check in with each other as we work.
And are you aware that he did not inventory or write down what was found inside the car?
I know he didn't inventory because we don't do vehicle inventories.
Ladies and gentlemen, stand for a moment.
Without objection.
They're admitted without objection.
Appendix 23, please. Agent, did you take that photograph?
Yes, I did.
You had it earlier shown us a photograph of a cigarette pack. Is that in this photograph?
Not that I see, no.
Defendants 20, please. So with reference to States 23, with the gift of modern technology, can you now identify that photograph?
Yes, I can.
Is there a cigarette pack?
Yes, there is.
And how did the cigarette pack get from the parking lot to the interior of the car?
It was placed inside the vehicle prior to it being towed.
By,
I believe myself.
and why would that be done before a photograph was taken?
Why would what be done before a photograph was taken?
The photograph is supposed to represent what the vehicle looked like, what it was last occupied. Is that correct?
That's correct.
And was there any evidence that you had that that cigarette pack, the lighter, was in any way connected to this vehicle?
I believe I was advised at the time that they had come from inside the vehicle.
And so were they fingerprinted, or there was DNA, or what type of test was done?
No testing was done on those.
State's exhibit, defense exhibit 20. Tell us what that is.
That's a photograph of the rear driver's seat of the Mercedes.
And what objects are in the rear of the Mercedes?
Looks like a bag of mandarin oranges, a brown paper bag with contents inside, and I think I remember that being a bag of carrots.
And what was in the bag?
The brown paper bag?
Yes.
I don't recall. It would have been looked at when we went through the vehicle.
Is there a photograph of that?
I don't believe so, no.
Is there an inventory of that?
No, there's not.
With respect to States 21, did you take that photograph?
Yes, I did.
And what is that photograph?
A photograph of the trunk of the Mercedes.
And what can we see in that picture?
I believe those are motorcycle parts.
And whose motorcycle was it?
I don't know.
Did they have any evidentiary value?
Not that I was aware of, no.
Did you take a serial number for those parts?
I believe we looked for a serial number or some sort of identification marks.
And in fact, there is no such thing as a serial number on those motorcycle parts. Is that correct?
I don't know.
You don't know?
I don't know if there's a serial number on motorcycle parts. That's why one was looked for.
But if somebody suggested that there was a serial number, certainly you must have been there when that serial number was looked for. Did you look for a serial number? Did you look for a parts number? Did you look for anything that would identify the ownership of those parts?
I believe so, yes.
And did you find a serial number?
Not that I recall, no.
So without a serial number, there couldn't be any call to somebody to say whether these were stolen parts.
I recall Agent Brown making a phone call in reference to the motorcycle parts, but that's all I remember.
Are those police motorcycle parts?
I have no idea.
Did you examine Officer Slager's vehicle?
Yes, we did.
Did you examine the interior of Officer Slager's vehicle?
I believe so, yes.
It's my understanding that you did an inventory of Officer Slager's vehicle, but what is State's Exhibit number 24?
That is the trunk of the patrol vehicle.
Was there a shotgun in the car?
I don't recall.
Was there a long rifle in the car?
I don't recall.
What is in that red bag?
I don't know.
Are you familiar that patrolmen go around opening citizens' doors for them using an instrument that can unlock a door?
I've heard that, yes.
And is this the type of bag that it's carried in?
I don't know.
You had indicated that you came back to the scene where the incident took place days later. Is that correct?
Yes, that's correct.
And you accompanied somebody, I think the word you used, who was doing a Faro. Is that F-A-R-R-O or O-W, Faro scan?
F-A-R-O.
F-A-R-O. And is that initials that stands for something? Or is that just a brand name?
I'm not sure.
Tell us what a Faro does to assist you in examining the crime scene that could be helpful for the jury to determine facts in this case.
It's a 3D camera that's mounted on top of a tripod, and it takes multiple scans of a location so that at a later date those scans can be overlapped to provide a 3D view of an area.
And this is a relatively newfangled innovation in law enforcement, is that correct?
From my understanding, yes.
It's something that goes back to the 1990s,
I don't know the history of the Faro.
but it has been used by SLED at least as of April 4th, 2015 on numerous occasions. It was a piece of exploring evidence that was utilized by SLED. Is that correct?
Yes, that's correct.
And there's somebody at SLED by the name of, is it Talon, Agent Talon, who's trained specifically in the use of Faro. Is that correct?
Yes, that's correct.
And that Faro scan was utilized at both the incident site and in the warehouse. Is that correct?
Yes, that's correct.
And as far as the warehouse goes, what was Faroed, is that what you call it? Faroed or scanned, or how would you?
Either one's fine.
If something would, at the warehouse, you Faroed Mr. Scott's car?
Yes, we did.
And you Faroed Officer Slager's car?
Agent Talon farrowed a patrol car that was similar to Mr. Slager's car.
And so the answer is no, you didn't Faro Officer Slager's car.
No, we did not.
You just picked one out of the parking lot that looked white and had blue lights on it and North Charleston insignia on the side, and you Farrowed that.
One that was similar to his vehicle, yes.
But his vehicle was there locked up in this secure warehouse. Correct?
I wasn't aware of that.
Now, that information, that Farrowed information is available for this jury, is that correct?
I believe so, yes.
The first time the Faro was used, the case agent said, stop. We don't want a Faro. Is that correct?
Yes, that's correct.
Which prevents the jury from seeing the original Faro at the crime scene at the earliest possible time, closest to the date of this incident. Isn't that correct?
Yes, that's correct.
And how many days later did Mr. Talon and Ms. Peterson and the rest of the crew go back to Faro the incident site?
I believe that was done on April 23rd.
19 days after this incident.
That's correct.
It didn't rain every one of those 19 days, did it?
Not to my knowledge, no.
And that Faro from 19 days later is available for the jury to look at. Is that correct?
I believe so, yes.
And that Faro of the incident site is a 3D Faro. Right? It's a 3D image taken by the Faro.
It's multiple images taken by the Faro.
So that a juror, if they wanted to, could look at a 3D image so they could better ascertain the locations, the distances, the view of the parties involved that day, as opposed to a 2D photograph.
That's correct.
Because we all know that Earth is round, correct?
Yes,
But a map of the Earth is flat, correct?
that's correct.
And when we lay out the flat map of the Earth, sometimes it doesn't give us the relationships, the distances that a globe reveals. Is that correct?
That's correct.
And that's basically the difference between a 3D and a 2D observation. 2D is not as good as 3D in terms of distances, in terms of planes in which evidence might exist. A Faro scan, the reason for that is to give the jury a better understanding of the relationships. Is that correct?
That could be one of its purposes, yes.
scientists are at SLED? Do you have any idea?
No, I don't know.
Do you know that the laboratory building at SLED is 3 or 4 stories tall,
Yes, I do.
maybe 100 yards in length?
I don't know how large our lab building is.
And they do forensic testing for ballistics, for tasers, for trace evidence, for DNA. A lot of science is utilized in that building, correct?
Yes, that's correct.
And part of that science would be taking Mr. Slager's, you take this downstairs, part of Mr. Slager's shirt and examining the shirt other than just with the eyeball. It can be examined microscopically, correct?
That's correct.
That was done, correct?
I believe it was microscopically examined in a specific area.
For what purpose?
I think it was to look for any sort of defects, marks, etc., that may have been present in that area.
And in fact, they were found, isn't that correct?
I believe so, yes.
And in fact, those defects that were found on Officer Slager's shirt were consistent with the taser being pressed against him. Isn't that correct?
I would object that this goes beyond her area of expertise, and she didn't do the examination.
You can answer if you know.
That's outside my area of expertise.
It's outside your area of expertise, but it's not outside your area of knowledge, is it?
I was made aware that the shirt had been microscopically looked at, yes.
And that it was consistent with the taser being used against it.
I can't speak as to what is or isn't consistent in reference to what was found within the trace department.
But it was Officer Slager's shirt, correct?
Yes, it was.
Now, were you present or are you aware that Officer Slager's shirt was examined both in daylight, white light, and infrared light?
Yes, I was aware.
You were present.
That's correct.
That wasn't done until January of this year, correct?
That's correct.
And the microscopic examination of the shirt wasn't done until 2 weeks ago.
That's correct.
And that shirt has been in SLED's possession for 18 months, correct?
I believe so, yes.
And we know that a visual examination does not always produce all the information the jury would need to make factual decisions in the case. And that's why it's sent to a laboratory, is that correct?
That's correct.
So that the jury may have the benefit of a microscopic examination, is that correct?
That's correct.
So that the jury may have a benefit of an infrared photograph of the shirt, is that correct?
That's correct.
So that the jury can have the benefit of an ultraviolet light examination of the shirt. Is that correct?
Yes.
And all those are tools that are in the toolbox at SLED to examine evidence in murder case.
Those are tools that are available, yes.
Now, do you know, or do you not know, if the case agent in this case, Peterson, stopped the examinations?
I don't know that, no.
When a piece of evidence gets to the laboratory, who controls what testing is done of the evidence?
That's usually a conversation that's had between the primary crime scene agent and the case agent.
So it would be between the primary crime scene agent, Mr. Brown,
That's correct.
and the case agent, which would have been Ms. Peterson.
Yes.
And they're in control, not the person in the lab who has the science background and the technology of how to examine for evidence that would be reliable, accurate for this jury to see?
If a request comes to them, they do have their input as to what's within or not within the scope of their analysis.
And if a laboratory personnel, a PhD or master's degree as you have, make that recommendation, it's not always followed, is it?
It depends on the circumstances.
Well, we know in this case it wasn't followed, correct?
What are you referring to?
I'm referring to the examination of Officer Slager's shirt with ultraviolet lights. Are you aware of that? Are you aware of the laboratory notes which documents the fact that a examination of the shirt was interfered with by the case agent?
No, I'm not.
Have you looked at the laboratory notes?
Which laboratory notes are you referring to?
State Law Enforcement Division, Columbia, South Carolina.
There's a lot of analysts there. Which notes are you referring to?
Not an objection, asked and answered. She was part of the note, I think she's entitled to see it. If she's not a part of the note, she has no personal knowledge to testify one way or another.
Rephrase the question, please.
Thank you.
Anything further of this witness by the defense? Redirect.
May I, Your Honor?
Yes, sir.
Agent Johnson, at the time you responded, this was just another officer-involved shooting. Is that correct?
That's correct.
And y'all examine or investigate lots of officer-involved shootings. Is that correct?
Yes, we do.
And the information that you have available to you on April 4th, 2015 was Mr. Scott had ran, taser activated, struggle over taser, officer shot him. Pretty much?
Pretty much, yes.
And I had already pretty much decided at that time this was probably a legitimate exercise of police authority.
It sounded like that at the beginning.
Okay? And y'all treated this case like that, correct?
Correct.
Because y'all clear most of these cases by finding that the officer acted lawfully, correct?
I believe so, yes.
That all changed when?
Are you referring to April 4th?
Pardon me?
I said, are you referring to April 4th?
Didn't change on April 4th. When did it change? How about the video? When the video came out, did that change this investigation?
Yes, it did.
Now, when you were examining this taser on April the 5th, all you knew was that there was a struggle, correct?
That's correct.
And that the taser may have been struggled over, correct?
Yes,
You had no specifics, correct?
correct.
I'm going to object to the former question. This is redirect.
What were you trying to find on that
The
taser?
objection is the former question.
Okay. Question was rephrased as an objection. Do you have an objection to the latest question?
I have an objection to any leading questions.
All right. Pose the question and do not lead.
What were you trying to find on that taser?
Touch DNA
From who?
from anyone that may have been in contact with the taser.
Was there any reason to believe that Mr. Officer Slager's DNA would not be on that taser?
We expected that his DNA would be on the taser.
So, who other DNA were you looking for?
Mr. Scott's DNA.
Well, y'all wanted Mr. Scott's DNA to be.
Objection to the phone.
Objection sustained.
Are you a law enforcement officer?
Yes, I am.
Is SLED a law enforcement agency?
Yes.
Did you have any information at the time on April 4th or April 5th, whichever prompted you to examine this taser for blood or body fluids or trace?
Need to hear the entire question.
I said, did you have any information available to you on April the 4th or April the 5th that would have prompted you to examine this taser for blood or body fluids or trace or anything of that nature?
Objection's overruled.
No.
Did you have any information on April the 4th or April the 5th to the effect that a struggle had not occurred between Officer Slager and Mr. Scott?
No.
Was there ever any question in the investigation by SLED as to whether or not a struggle had occurred?
Not to my knowledge, no.
And I believe you testified on cross-examination that you did not swab the business end of the taser. Is that correct?
That's correct.
And why is that?
At the time, I don't believe we knew that anybody had been drive stunned.
Anybody, correct? Mr. Scott or Mr. Slager? Would that be a fair statement?
That's correct.
To your knowledge, has Mr. Officer Slager ever claimed to have been drive stunned?
Not to my knowledge, no.
And he's been interviewed by SLED, correct?
Yes.
I mean, to this day, do you have any knowledge?
Not to my knowledge.
Now, the registration of that vehicle that was shown to you, do you recall whose name it was in?
Arthur L. Hayward.
And were you aware that Arthur Hayward was a motorcycle aficionado, much to his bad luck at this point, I'm assuming, but did you know that?
I did not know.
And getting back to the uniform shirt, was there ever any reason to test the uniform shirt for taser?
No,
And why is that?
because we had not been made aware that that testing needed to be conducted, that there was a question that needed to be answered in reference to the taser.
Because why?
Because we had not been told that Mr. Slager had been tased, drive stunned at any point.
Not by anybody else or Officer Slager, correct?
That's correct.
And just one other thing. Back in January of this year, y'all did a bunch of photography regarding Officer Slager's uniform, correct?
Yes, that's correct.
And it was with white light, infrared light, and ultraviolet light, and all these alternate light sources, correct?
Yes.
Do y'all have any information as to what marks, if anything, a taser would cause on a shirt?
No, we do not.
Are you aware of any studies that have been done regarding that?
No.
Did y'all even know what you were looking for?
No, we were simply documenting what the shirt looked like, any sort of picks, holes, just defects in general that we saw were just notated.
Okay. And you were basically documenting the condition of the shirt?
That's correct.
Court's indulgence. Do you know if that shirt has always remained in the custody of SLED since it was collected?
It's been shipped out to a different location for external testing.
By the defense team, correct? Yes.
The objection is overruled.
To the defense team, correct?
Yes, that's correct.
Do you know where that was sent and how long was it?
I believe it was sent to WD Forensic in Seattle.
And do you recall when it was?
I believe we mailed that out on January 28th of this year.
Thank you.
Further cross-examination.
Not sure I understood this correctly, but it sounded like SLED throws cases towards law enforcement when the investigator. Is that what SLED does?
No, that's not what we do.
So the SLED reaction to this incident site and the people involved was to determine the facts of what happened, not to slant the facts in favor of law enforcement. Is that correct?
That's correct.
And that took place before the video was obtained. Is that correct?
What took place before the video?
Your investigation, was it slanted to the law enforcement community until that video showed up?
Our investigation is not slanted one way or another.
Is it ever slanted towards police officers?
My investigation from a forensic standpoint is never slanted one way or another.
And you don't take a political position with respect to cases, you just tell the jury what your findings were. Isn't that correct?
That's correct.
Now, this shipping of the shirt to the West Coast took place when?
I believe January of this year.
And at that time, SLED was in possession of the shirt for some 9 months.
That's
Is that
correct.
And you know that this judge didn't allow that shirt to be transferred until the state said that they had completed all the examination of that shirt that they would do or ever do. Isn't that correct?
I don't know.
And it's only after the defense examination that SLED decided to start looking for other evidence. Isn't that correct?
What other evidence are you?
Evidence that a taser had been used against the shirt.
We don't look specifically for evidence that a taser has been used against a shirt.
What was the purpose of looking at the microscopic fibers of the shirt?
I can't comment as to a trace analyst's job.
Let's talk about trace analysis. Trace involves gunshot residue,
Yes.
transfer of fibers,
Fibers?
yes,
Yes.
transfer of hair,
Yes.
transfer of touch DNA,
Potentially, yes.
examination for bodily fluids, sweat, blood, tears, correct?
I'd say that's more on the DNA side of the house than on the trace side of the house.
How about dirt? Nothing complicated about dirt, is there?
I hope not.
And it wasn't until 2 or 3 weeks ago that SLED discovered that there was dirt in the pocket of the Slager shirt. Isn't that correct?
I have no knowledge of any dirt.
You don't keep up with what the lab does?
I do keep up with what the lab does, but I hadn't been made aware of any dirt.
As the crime scene investigator, were you aware that there was yellow paint on Mr. Scott's cell phone?
Not until recently, no.
And as the SLED evidence gatherer, did you go out and take a scrape of paint from yellow brick roads?
No, I did not.
And the purpose of doing that would be to compare it with any paint samples that may have been on the phone?
If there was a question as to where the phone had been, yes.
And SLED was given paint samples by that defense person in Seattle to examine, were they not?
I don't know what the trace department was given in reference to paint.
And those paint samples stayed in SLED's possession for 9 months without any examination. Isn't that correct?
I don't know how long they've been maintained.
Now, there's an inference that came that perhaps the shirt was tainted or in some way disturbed by the defense. Was that your understanding of the question?
I didn't take it that way, no.
Well, what would be the purpose of the question to ask you if it left the hands of SLED?
Your Honor, the question sustained.
Did you take photographs of the shirt before it went to Wine Laboratories?
I believe the photos that we took at the beginning of January document the overall nature of the shirt.
And that was before the shirt was shipped, correct?
That's correct.
So that there was any destruction or messing or tainting of the evidence, you all have proof of that, correct?
That's correct.
And there was no tainting by anybody associated with
Form of the question.
is there any evidence that your testimony about the transfer of evidence to the defense, is there any evidence that it was in any way disturbed, changed, challenged, or anything of that nature?
No.
Or was it an answer to the defense?
No.
And in fact, a SLED agent was present in Seattle upon the defense opening the package and seeing the fibers on the taser, correct?
That's correct.
The defense didn't touch it until SLED arrived in Seattle so that you could observe, not you, but the SLED agent could observe the testing. Is that correct?
I believe so, yes.
And prior to that time, the state lab never evaluated what fiber transfers may have occurred on the taser. Isn't that correct?
That's correct.
And before the taser was shipped to Taser International in October of 2015, the defense had no opportunity to examine the taser, correct?
I don't believe so, no.
And if the taser was shot and used and triggered or whatever, any fabric that may have been on the taser would have been destroyed during the course of the state's examination of the evidence. Isn't that correct?
I can't speak as to trace evidence possibly being destroyed.
But that was in the custody of the state of South Carolina when that testing was done. Correct?
The Taser International testing or the
Yes,
fiber?
Taser International.
No, that was sent to, the Taser was sent to Taser International.
With a check from the State Law Enforcement Division. With a check. So that it was a state sponsored examination. Is that correct?
I don't know who paid for the taser examination.
And the defense was never allowed, of course, to participate in that observation of that examination. Correct?
Not to my knowledge, no.
And the state didn't have an opportunity at that time to prevent any disruptive testing. Isn't that correct?
Not to my knowledge, no.
3 days later, after the defense heard about it, this judge issued an order, no more disruptive testing of any evidence. Isn't that correct?
I believe so, yes.
No further questions, thank you.
Thank you.
You may step down. Ladies and gentlemen, we'll take a break now. Please go to the jury room and do not discuss the case. You'll wait for the jury to leave. Step down, we'll take 10 minutes.